So next up for Illinois' gun ban could be the Illinois Supreme Court in a case that was brought by attorney Thomas DeVore in Effingham County that he got a temporary restraining order on. The state appealed that in the Fifth Circuit, and the Fifth Circuit Appellate Court upholding the temporary restraining order that attorney Thomas DeVore secured. And now the Illinois Attorney General looking for an expedited review of that in the Illinois Supreme Court. Last segments, we went through some detail about the Fifth Circuit Court of Appeals split decision where they decided to uphold one of four charges that DeVore brought against the measure that's now enacted across the states. But DeVore's actions only impact the 866 plaintiffs in the Effingham County case. He has a similar case in White County with 1,700 plaintiffs, and we could see a temporary restraining order issued in that case as early as today. It's hard telling when that's going to happen. But now that the Fifth Circuit has shown where they stand on this, you could see a domino type of effect of sorts of similar cases being filed or cases that are already filed going a similar direction until we get to some kind of ultimate conclusion. But I talked with attorney Thomas DeVore yesterday, and we'll share that with you. But I, of course, want you to chime in anytime at 217-629-7970. That's the phone number here with Springfield's Morning News. But when I connected with attorney DeVore, it was really just to get his initial reactions and to address some of the other questions that are being brought up about, for instance, whether or not this is applied to the entire state. Because we're seeing some mixed reporting there. Yes, in a way, it does apply to the entire state, but from what I understand, is it's only if there is some kind of lawsuit that's brought in another county. So, for instance, we'll hear from Tom DeVore about this. He says that if, for like Sangamon County here in Springfield, if a case was brought, then it would have to comport with the ruling from the Fifth Circuit until obviously it goes all the way up to where it needs to go to like the Illinois Supreme Court, because this is a state level case. So these are all the state level issues. A lot of people are saying, pay attention to that, but also look at federal cases. And we've got some federal cases that are in the hopper with, especially in Naperville, possible temporary restraining order that's pending up there. And that would be for just Naperville. You also have, other cases that have been filed in federal courts where they're starting to try to get some hearings and judges set up and all of that. But attorney Thomas DeVore, when I chatted with him yesterday, it was practically an hour or so after the Fifth Appellate Court District issued their ruling upholding the temporary restraining order. And here's some of what DeVore had to say when we chatted yesterday.
All right. Well, our particular count, we only had four. I think there's five maybe in Mr. Stock's case that he filed in Effingham County or in Macon County. He had an additional claim. Ours raises four. And, the appellate court said that as far as likelihood of success with the record that they had in front of it, they found equal protection violation. There was a likelihood of success. It doesn't mean that the other arguments that we've made won't be successful. They just said with the record they had in front of them, they couldn't say that that's been established. And I'm okay with that because we've got some discovery and other things that we've got to go through to really lay out those procedural issues. And the appellate court's ruling, they take them to task on all of those procedural issues, so they understand them. But as of right now, at this very preliminary stage, the appellate court said equal protection is the problem. And when you and I have talked about this in the past, Greg, I always said in the short term, absent the record being fully vetted and generated, equal protection was by far the most pertinent argument in the short run. So the appellate court agreed with us and said that the TRO stands because there's been an equal protection violation. As far as how it affects the other cases, this is now a published case. It's the only case in Illinois on this issue. And so the other cases that have been filed, this is precedent for them. And so they'll be likely issuing, not just in case I might have filed, but in other cases filed by Mr. Stocks and others that have asked for restraining orders. Then those courts, I fully expect, will issue those restraining orders. And then we'll see if the appellate court or the Supreme Court is interested in hearing this issue on what's called an interlocutory basis. I don't know if the Supreme Court is interested right now. They may want to wait until the record has been fully complete and developed before they go down that path. And so we'll see But I think the federal courts, the cases in the federal courts, are going to pay particular attention to this equal protection ruling too, because it's going to become very relevant in the federal case.
So just to pause here for a moment, a lot of people pointing to the Second Amendment, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. But that argument, of course, in federal courts could be very fundamental to what happens with the state's gun ban, let alone other gun bans that are being challenged, like over in Maryland, where that case is much further along than Illinois' cases in federal court. But the state court level, DeVore brought this issue of equal protections forward, saying it's very crucial. And just to reiterate, the 4 charges that he initially brought, one was the 3 readings rule, appellate court threw that out, the due process court threw that out, the issue of single subject, the court threw that out. It was the issue of equal protections that the court upheld in their TRO, upholding yesterday in the appellate court. Why is that so important? I asked Tom DeVore to explain that for the layperson.
The equal protection argument is that this law carves out 7 categories of people based on their profession, that they're not bound by this law. They can buy all the AR-15s they want. They can buy all the 50 calibers they want. They can buy all of the 30-round magazines they want, purely based upon where they work. Current retired police, prison guards, county jailers, security people, and the government tried to argue that that was based upon their extensive training. That was the reason that they were able to be carved out. And there's a lot of problems with that, Greg. One is that does being trained further the purpose of this law? That's a fair question. And second and most importantly is, then if training is the issue, truly the issue, then every citizen in the state of Illinois should have the same opportunity to take some comparable training as to these categories of professions and retain their rights. And so, we argued both of those in this case, that one, this is not about training. It has nothing to do with training. It doesn't make any sense. And to the extent it is about training, we have a right to then seek that training as well as citizens and not lose our right to purchase and possess and not register these weapons. We just go take the training that they think is reasonable. And again, the appellate court agreed with us, at least in the interim, on that issue.
So Attorney Thomas DeVore chatted with him literally an hour after the ruling from the Fifth Circuit dropped, upholding the temporary restraining order for 866 plaintiffs. And that could be extrapolated in other court challenges, including in White County and even in Macon County with an emergency hearing that's set for Friday, or other state-level cases. So we'll be back with more. I want to share more with what Tom DeVore had to say, but also lawmakers from both sides of the aisle I was able to connect with yesterday briefly at the Illinois State House, so we'll share that with you as well. It's right here.
Take Springfield's morning news with Greg Bishop everywhere with a free WMAY mobile app. 92.7 WMAY, Springfield's news and talk.
All right, final few moments here of conversation I had with Tom DeVore, the attorney that brought the case in Effingham County that got a TRO and ultimately led to the Fifth Appellate Circuit Court appellate courts to uphold that TRO about the issue of equal protections. And I asked him about this is a temporary restraining order that's been upheld. What about permanent injunctive relief to block this thing statewide? Here's some of what he had to say yesterday.
The only time it's ever going to get to an injunctive relief outside of our plaintiffs would be if the Supreme Court made that decision like they did in the Safety Act case, which is possible, but I have no idea to speculate. If there's some federal case that issues a statewide ban, it could be, that's yet to be seen. The case that we brought, for a variety of reasons, didn't seek a statewide injunction because that's the complexity in a state court that, nobody's went down that path, and I understand why. So I can't speak to that. But a federal court could do it in one of these federal cases. I've been talking to the guys that have a couple of these federal cases in very great detail, and I'm trying to get them to do some of these things. But we're going to come back to the state court case. The injunction will remain in place, and then we're going to do a little bit of discovery, and we're going to get to the bottom of these procedural problems that we've raised. We're going to start asking a lot of questions for a lot of information and do some depositions of these legislators, and we're going to ferret out these procedural issues, because I think they're very important, Greg. They have to be addressed. And at the same time, again, you have the equal protection argument that I don't know how the government's going to get around in the long term, whether it's the state court or the federal court. The equal protection argument is significant, as well as, again, ultimately in the federal cases when they get to that point, Second Amendment. So
now we've seen it reported elsewhere that this is good for the entire state. I asked DeVore about that. How it's being reported. Here's what he had to say.
Is that when this court entered this ruling, that there is again, right now, a likelihood that this law violates equal protection, that opinion would be binding on every circuit court in the state that might choose to consider this issue. So if somebody files a case in Sangamon County with the circuit court saying that injunction should issue because you're violating my equal protection rights, that circuit court case or court is bound by that opinion. That's what that means, if that makes sense. So,
again, just hearing from the attorney that brought this, his understanding of how this could be applied statewide, though it isn't immediately applied statewide. I talked with state lawmakers from both sides of the aisle yesterday, including a Democrat State Representative Maura Hirschauer. She fought to pass this bill, and I got her reaction to the appellate court upholding this restraining order.
We've been expecting kind of any twist and turn that can come, so I feel really confident that we have passed the best bill we possibly can, and that our attorneys are ready to fight it, and still feeling positive. You know, I think I stand with my constituents who are tired of waking up every morning to hear about another mass shooting, whether it be in our state or in states across the country. We took a stand here in Illinois that our constituents wanted us to, and I'm proud of the work we did.
So again, that was Maura Hirschauer, a Democrat who fought for the passage of the Protect Illinois Communities Act. But I also talked with Dan Calkins, who has his own case that he's brought in Macon County. And he's confident that things are going to turn out pretty good in his case. Here's Dan Calkins, a Republican from Decatur, when I connected with him briefly on the third floor of the Illinois Capitol, where I find myself at work outside of the radio show. So here's Dan Calkins.
I think it's great news. Congratulate Tom DeVore for getting this in and being able to defend his case in the appellate court. Now we'll see what happens in Effingham in the courthouse. Is it going to go to trial? And if it goes to trial, how that works out. But I think it's good news. It's a good sign. Hopefully it'll have a big impact on how we do business here. I don't think I can figure out what a judge is going to do. Every case is different. Our case is a little different than Tom's, but it follows the same track. We'll see 1:30 on Friday what the judge is in for. Generally, I've been told judges don't like to go against another judge in the same circuit. So we're very hopeful that we'll get a positive response from the judge.
So we'll see what happens there in Macon County with the case brought by Dan Calkins, but these are just state-level cases. We have yet to really see much substantive movement other than oral arguments in federal cases, one being in Naperville where there's a possible TRO ruling that we can expect soon. But you have 4 other cases in federal courts that could be advancing. We'll be watching all of this and bringing you the latest here. I'm Greg Bishop. Follow me anywhere, Bishop on Air, Twitter, Facebook, YouTube, Bishop on Air.
SPI Studios. Take the easy